Amendments A. More reasonable inference to be drawn from the whole scheme of the Constitution is that some other meaning of amendment is more appropriate. This conclusion is also reinforced by the concession on behalf of the respondents that the whole Constitution cannot be abrogated or repealed, and a new one substituted, in other words, the expression amendment of this Constitution docs not include a revision of the whole Constitution. If this is true, then which is that meaning of the forward amendment that is most appropriate and fits in with the whole scheme of the Constitution, that meaning would be appropriate, which would enable the country to achieve a social and economic revolution without destroying the democratic structure of the Constitution and the basic inalienable rights guaranteed in Part 3, and without going outside the contours delineated in the preamble. The bribery com, Nishaner vi we, Pedrick Ranasinge, 1% 5. AC 172, M. Kaliv the King, 1920, AC 691, and in re, the Regulation and Control of Aeronautics in Canada, 1932, AC 54 at P70 referred to. The same conclusion is arrived at by another line of reasoning in a written constitution. It is rarely that everything is said expressly. Powers and limitations are implied from necessity or the scheme of the Constitution. The Solicitor General, appearing on behalf of the Union of India, conceded that implications can arise from a constitution, but said that no implication necessarily arises under the provisions of Article 368, reading the preamble, the fundamental importance of the freedom of individual, indeed its inalienability, the importance of the economic, social and political justice mentioned in the preamble, the importance of the directive principles, the non-inclusion in Article 368 or provisions like Articles 52, 53 and various other provisions, an irresistible conclusion emerges that it was not the intention to use the word amendment in the widest sense. It was the common understanding that fundamental rights would remain in substance as they are and they would not be amended out of existence. It seems also to have been a common understanding that the fundamental features of the Constitution, namely secularism, democracy and the freedom of the individual, would always subsist in the welfare state. In view of the above reasons, a necessary implication arises that there are implied limitations on the power of Parliament, that the expression amendment of the Constitution has entirely a timid meaning in our Constitution, and not the meaning suggested by the respondents Balpori 1, 16, 3, 164, 457, and in the initiative in RFDM ACIL 1919, AC 935, Applied Hawk-Smith 64, LED 871, Rhode Island v. Palmer 64, LED 946, Uniled States of America v. William H. Saraga 1, 75, LED Zeke 40, Commissioner of Stamps, Straight Settlements Vui Chong Swan, 1933, AC 378389, Bank of Toronto v. Ambe, 1887, 12 AC 575587 and Thief State, at the prosecution of Jeremiah Ryan, Varsawan, Captain Michael Lennon and others, 1935, Irish Reports 170, Distinguished D. If the argument that there is no limit to the power of Parliament to amend the Constitution is accepted, Article 368 can itself be amended to make the Constitution completely flexible or extremely rigid and unamendable. If this is so, a political party with a two-third majority in Parliament for a few years could so amend the Constitution as to debar any other party from functioning, establish totalitarianism, enslave the people, and after having effected these purposes make the Constitution unamendable or cxu cloi rigid. For the aforesaid reasons, one is driven to the conclusion that the expression amendment of this Constitution in Article 368 means any addition or change, preamble and the Constitution to carry out the objectives in the preamble A, the directive principles. Applied to fundamental rights, it would mean that, while fundamental rights cannot be abrogated, reasonable abridgments of fundamental rights can be effected in the public interest. It is, of course, for Parliament to decide whether an amendment is necessary. The courts will not be concerned with the wisdom of the amendment. This meaning would enable Parliament to adjust fundamental rights in order to secure the directive principles direct row be accomplished, while maintaining the freedom and dignity of every citizen. Sound amendment within the contours of the preamble and the Constitution cannot be said to be a vague and unsatisfactory idea which parliamentarians and the public would not be able to